Hello, everyone. Bonjour. Welcome. Um, uh, I'd like to welcome you all to today's webinar on the Charter's lesser known section, Section 16, and Canada's official languages in the Charter, with Professor François Larocque, who is coming to us from the University of Ottawa. Bonjour, François. I am Pat Paradis, the Executive Director of the Centre for Constitutional Studies in the Faculty of Law at the University of Alberta, and I'm very pleased to be moderating today's webinar, which is a part of the Centre's Charter Series. And with the Charter Series, we bring in experts from across Canada to explain various sections of the Charter to the general public. And it's our hope and intention, I would have to say, that people will come away from these presentations with a greater understanding of how our charter actually works and how it impacts their everyday lives. We've certainly seen a need for that in the last couple of weeks here in Canada. Now, to begin, I'd like to encourage you all to take note of the land that you inhabit. This webinar is coming to you from Treaty 6 territory, and we honor the ancestors, traditions, and the spirit that first drew people, the Cree, Blackfoot, Nakota Sioux, Iroquois, Dene, Saulteaux, and Métis, and then settlers to this gathering place. And we are grateful for the many benefits we've received as a result of treaty, which was signed in 1876, Treaty 6. We also recognize the ongoing acts of settlement and colonization that take place here, and that honoring this land and the ancestors, its ancestors, is only a very small part in recognizing the spirit and intent of the treaty and of our efforts toward reconciliation. Now, today's webinar will be about 1 hour in duration. Professor Larocque will speak for approximately 30 to 40 minutes about Section 15, its history, its purpose, its future in our Constitution. And then he will answer questions from you, our audience, and you'll be able to enter questions throughout his presentation using the Q&A button at the bottom of your screen. And before I introduce our speaker, this is just a reminder that the webinar is being recorded and that it will be available on our YouTube channel at the Center and accessible on the Center for Constitutional Studies website later this afternoon or Monday, and you will be receiving notification that it has been, that it is available. All right, and now to introduce our speaker. François Larocque is a professor in the Faculty of Law at the University of Ottawa, Common Law section, and a 2021 Pierre Elliott Trudeau Foundation Fellow. Before law, Professor Larocque studied philosophy, obtaining both his BA and LLB degrees at the University of Ottawa and his PhD at the University of Cambridge as a Commonwealth Scholar. He was also a Shirk Doctoral Scholar, a Fondation Baxter and Alma Ricard Scholar, and Honorary Prince of Wales Scholar. Currently, his research focuses on civil liability for breaches of international human rights and language rights in Canada. In fact, he holds the research chair on language rights and is a member of the University of Ottawa's Collège des chaires de recherche sur le monde francophone. François has published on the philosophy of law, Canadian legal history, civil liability, human rights, and international law. His recent publications include as an editor on the book Doing Peace in the Rights Way, International Law and Human Rights in Conflict. And he is one of the authors of the article Loi sur les services en français à 25 ans, constats et propositions, published in Revue du Nouvel Ontario. And so, without further ado, le professeur Larocque, would you please begin?
Hello, thank you so much, Patricia, for a generous introduction. And I'd like to thank all the members of the team of the center, specifically Alina and Zara, for their kind assistance in preparing for this presentation today. Well, as was mentioned in the introduction, I am a professor of law at the University of Ottawa, and I hold the research chair on language rights and issues. I used to do more work on international human rights, and it's still, I would say, a general area of interest but my focus these days has been squarely on language rights. Um, and in addition to being a professor of law and language rights, I am also a lawyer, and I work as of counsel at a firm called Power Law. You might have heard of them. They're actually a boutique litigation firm, public law litigation firm, based in Ottawa and Vancouver and Montreal, which is a vibrant practice in constitutional law and administrative law, Aboriginal law, and in my little niche area of language rights. I can't think of another firm that does as many cases in language rights as Power Law. And through them, I've had the privilege of arguing cases at every level of court in Canada, up to the Supreme Court of Canada, but also in Alberta. I was involved, the privilege of being involved with the Caron case, which went up to the Supreme Court twice on different matters. And I'm very pleased to be beaming into Alberta, so to speak, on this noon hour. I teach language rights, a class called Language Rights in Canada at the University of Ottawa. And it's a funny class for a law school because there aren't many law schools in Canada that offer it. Aside from the University of Law at Moncton, and also I believe Robson Hall, University of Manitoba, has a class on language rights. I don't think there are many classes in Canada taught on language rights and on this particular area of the Charter. So I'm very happy to be able to talk about these rights in question and Section 16 in particular. And I'm happy to do so in English, which is my second language, because I teach in French and I work in French mostly. And as one does, you acquire a lexicon when talking in whatever field. And in this case, my lexicon is mostly in French. So I'm really happy to have the opportunity to talk about these things in English. I'm happy to take questions at the end on anything I touch on in this presentation in the official language of your choice. So let me share a presentation. I have a virtual presentation here that I will share as a virtual background to my camera feed. Hold on. This has worked in the past, and it makes for the PowerPoint presentation around me. So you in theory should be able to see me and also see the slides around me. So Zara, can you confirm that all is working on your side?
Yes, looks perfect.
Fantastic, thank you. So let me just shut this so I can see. So by way of an outline, here's what I propose, how I divide up the time I have with you today. I will cover a brief history of language rights in Canada. And to talk about language rights in Canada is actually to talk about the history of Canada itself, at least of colonial Canada and the colonization of Canada by France and then by England. And we're actually all living with the consequences of those events. And then I will talk about the constitutional entrenchment of our language rights and with the focus on the Charter and also the Constitution Act of 1982, and two parts of that particular constitutional statute, which are very important. And then to finish, I will talk about what lies ahead, the future of official language rights in Canada, and all stemming and tying it back to our constitutional provisions under the Charter. So let us begin. A brief history. Now I'm covering centuries here of history in I hope about 5 or 7 minutes. And just to touch on a few keystone moments the first one is a heading called Colonization, Conquest, and Coexistence. Now, Canada was first colonized by the French, and as we know, and the Acadians settled out east starting in the 17th century, 1604 to be more precise. And so the eastern part of what is now Canada was the first European language to be spoken there was French. No offense to the Vikings that might have come or that did come earlier, but did not establish permanent colonies. Then, of course, the English arrived, and in the 18th century, there was conquest. So the fall of New France occurred, and in 1759, the Battle of the Plains of Abraham, and from that point on, forward, the Canada was under English rule. But the French did not go away. The French and English, in fact, coexisted in these new colonies, and some provisions were made for not only both communities to coexist, but for both languages to coexist. Even during the post-conquest period. So there was Upper and Lower Canada, as you recall, after the Constitution Act of 1791. And so the Upper Canada was mostly Anglophone, but with some French, and Lower Canada was mostly Francophone, but with some English. And so there was bilingualism was already being practiced. Statutes were being enacted in both languages, and one could use interchangeably those languages in the legislatures. Now, of course, there was many conflicts, and after the rebellions of Upper and Lower Canada, Lord Durham arrived and produced a report at the request of the English Crown on the causes of that rebellion. And one of the causes he found was like the fact that the English and French simply did not get along, and therefore we should fuse Upper and Lower Canada and impose one language, the English language, as the only language of the state. And that was one of the recommendations that Lord Durham made. And so in 1840, the following year, in the Act of Union, it was decreed that the legislature of Canada, the Parliament of Canada, would be English. The language of the legislature would be English, and statutes would be prepared in English only. Now that's what was provided in the Union, in the Act of Union, but it was never followed in practice. Parliament was moving between Kingston and Toronto and Montreal and Quebec. It was moving every couple of years. And in practice, parliamentarians were able to speak either language, and the statutes were also printed and adopted in both languages. So official bilingualism was being practiced as a practical matter in those early pre-Confederation days, to the point where when those colonies decided to form a country and decided to proceed with Confederation, it was agreed upon that the practice of being able to speak the language of your choice in Parliament and to enact the statutes in both languages would be maintained. And so in 1867, the British North American Act was adopted in English only. It should be mentioned, and I will speak more about that a bit further. The British North American Act was enacted, and Section 133 codified what had been up till then the unwritten practice, which is of being able to speak in Parliament in the language of your choice, to enact the statutes, the laws in both official language, and also that the courts established by Parliament and the courts established by the province of Quebec after 1867 would be able to use the language of their choice. So bilingual legislature and bilingual courts. That's what Section 133 of the British North American Act provided. So of course, Canada expanded further west after Confederation, and when plans were underway to acquire Rupert's Land from the Hudson's Bay Company, which was a British corporation ruling like a government over a huge swath of North America. It should be known, and it's not a well-known fact, that the ordinances, the statutes, for lack of a better word, that the Hudson's Bay Company through the legislature of Assiniboia were enacting statutes in both languages. The ordinances were being passed in both languages, and the courts, the recorder courts of Rupert's Land, were also bilingual. So again, bilingual courts, bilingual legislature, already being practiced out west in Rupert's Land under the rule of the Hudson's Bay Company. So when expansionism was being planned out, and people did not think to consult the indigenous populations and the Métis, well, the Red River Resistance occurred, and one of the rights that Louis Riel and the Métis Provisional Government sought, and it appears on the list of rights, as many of you perhaps know, was that, well, the previous practice of bilingual legislation and bilingual courts would be maintained in the new, once annexed to Canada. And so this was codified in the Manitoba Act of 1870 under Section 23. So Section 23 of the Manitoba Act is basically a mirror provision to Section 133 of the British North America Act. So maintaining bilingual courts and bilingual legislation. So the official languages, without being called official languages per se, were already in place with respect to legislation and courts for most of what would become Canada. But then shortly after the Manitoba Act was passed, there was a movement as immigration moved from Eastern Canada towards the West, that those provisions were inappropriate, and that in fact that Canada should be an English country, and so there was a very strong Anglo sentiment that two languages would only divide the country, and it would prevent Canada from forming a cohesive whole. So the idea of Anglo dominance came about. And so there was legislation in Manitoba trying to undo Section 23 of the Manitoba Act. And that was passed in 1890. And it was a statute to establish English as the only official language of Manitoba, and which caused statutes in Manitoba to be passed in English only from 1890 onwards. And that was maintained well into the 20th century. In fact, until the late 1970s, until the Supreme Court of Canada declared that statute to be unconstitutional, declaring all the statutes of Manitoba that had been passed in English up to that point only to be null and void, and therefore having to reenact them again in both languages to be consistent with our constitutional imperatives. And so these tensions that started in 1890 characterize a huge part of the end of the 19th century and the first part well into the second half of the 20th century. There was really it's the period of the two solitudes, where there was a lot of tension between the two main language groups, colonial language groups, I would maintain, and also there was efforts to basically make Canada a unilingual country. For instance, in Ontario, there was a regulation called Regulation 17, which prohibited the education of Franco-Ontarians in their language. Franco-Ontarians had to go to school in English only, and could only learn French 2 hours a day, and only up till grade 2. And after that, it was English only. And almost every province in Canada had legislation similar to that one, basically limiting the right of the minority to access education in their language of French and English. So all the provinces outside Quebec had legislation limiting the access to French language education, and Quebec also had legislation limiting the right to access English education, wanting to maintain the Francophone identity and Francophone character of Quebec. So these tensions came to I think, a boiling point in the 1960s. And this is where Lester B. Pearson, he's the small guy in the corner here, um, uh, called the Royal Commission on Bilingualism and Biculturalism, which was a pivotal moment because this commission got to work and went across the country and just tried to understand the nature of the Canadian identity and the tensions between the linguistic groups and what could be done to forge a future together where both languages could be recognized and could coexist peacefully, and where the minority population in both languages could also thrive. And the conclusion of that Royal Commission was to enact Official Languages Acts. So the recommendation was, there were several recommendations that came out of the Royal Commission on Bilingualism and Biculturalism. One was that Canada become an officially bilingual country with a statute that provided in detail the manner of that bilingualism. That New Brunswick become officially bilingual, that Ontario become officially bilingual, and also that Ottawa become an officially bilingual capital. And there were tons of recommendations like this. So in 1969, both New Brunswick and Canada enacted in that order the Official Languages Act. New Brunswick became an officially bilingual province 4 months before Canada became an officially bilingual country. So French and English were declared to be the official languages of both those countries. So not only were the courts going to be available in both languages, not only were the statutes going to be enacted in both languages, but government services would also be available in both languages at the federal level and in New Brunswick. Ontario opted for a more gradual policy of providing services, not through legislation, but on a basis of policy. Quickly forwarding through time, we come to Quebec Bill 101, which almost as a reaction to the Official Languages Act, wanted to reinforce and consolidate the French language in the province of Quebec. And which raised which was simultaneous with the movement of Quebec separatism. Then, of course, the big event, and which is what I'm going to concentrate most on today, is entrenchment and repatriation. So Canada repatriated its constitution, enacted the Charter of Rights and Freedoms, which we're talking about in these series, and we, in the process, also constitutionally entrenched our language provisions. So I will talk now about that process of constitutional entrenchment. And here, of course, that famous picture of Pierre Trudeau and the Queen signing the new Constitution Act of 1982, which includes, as part one, the Charter of Rights and Freedoms. So I will talk about the Charter, about part 5 of the Constitution, and part 7 of that same document, the Constitution Act of 1982, which are, again, sections that are the lesser known sections of the Constitution, as the title of this talk suggests. So when we talk about the language rights provisions of the Charter consists of, as you know by now, if you've been a regular attendant of these noon hour sessions, contains in fact 34 sections, right? So sections 16 to 23, that's 8 sections. So that's nearly a quarter. The entire Charter of Rights and Freedoms is dedicated to official languages. A lot of people don't realize that. So it's by far the most well-covered topic of the Charter is official languages. And so the sections briefly are as follows. 16 is the Declaration of Official Languages, and we'll talk about that section in a second. Sections 17 and 18 are basically mirror but amplified provisions of Section 133 of the British North America Act. The act that basically the sections that provide for the right to speak in Parliament in the official language of one's choice is now a constitutional right under Section 17. Section 18 provides that parliamentary statutes and records are in both languages, and that proceedings in the courts established by Parliament, so all the federal courts, are in the official language of one's choice. And there's a discussion right now as to whether that should be extended to the Supreme Court of Canada, because the Supreme Court of Canada, as it currently stands, is exempted from the provision in the Official Languages Act that allows litigants to not only use the official language of one's choice, but to be understood in the official languages of one's choice without the aid of an interpreter. So right now that right exists for all the other federal courts except the Supreme Court of Canada. And next week, we are expecting the federal government to table its new Official Languages Act bill, which, among other things, and I'll get to that in the conclusion, will remove that exemption to the Supreme Court of Canada. And many people are arguing that that's actually a reflection and a proper application of Section 19 of the Charter. Section 20 codifies the rights to all public services, essentially, and communications from the federal government in the official languages of one choice. Section 21, 22 are continuation provisions, and Section 23 is the big one in the sense that it is the minority language education rights, which creates positive duties and obligations for all the provinces to provide schools and or at least education programs to the minority official language community. So francophones outside Quebec and anglophones inside Quebec. So Section 23 is the reason why there are francophone schools across the country and why there are anglophone schools inside Quebec. Now, I want you to note that none of those sections between sections 16 and 23 are subject to Section 33 of the Charter, the famous notwithstanding clause. Remember, notwithstanding clause is the section that says that parliaments and legislatures can enact legislation that basically violate a bunch of our charter rights if they enact this Section 33. And it's Section 2, Section 7 to 15, but not sections 16 to 23. So the language rights are exempt from the notwithstanding clause. That just goes to show, I think, and goes to the point that of how important they are in the constitutional fabric of this country. They are not subject to the notwithstanding clause. And not only are they not subject to the notwithstanding clause, as we'll see, they are very solidly entrenched. And we'll talk about that in a second. But first, I want us to look at the main operative section, Section 16, which contains, in fact, 3 paragraphs. And I omitted paragraph 2 because all the sections that I flagged earlier, Section 16 to 23, to at least to 20th, to Section 16, 17, 18, 19, and 20, have a paragraph 2 that applies to New Brunswick. So New Brunswick also has all its language rights entrenched in the Charter. The paragraphs 1 of all of those sections are with relation to the federal government. So let's look at 16.1. English and French are the official languages of Canada. That's the first time the Constitution provides for that. In 1867, it did not say those words, that they're the official languages. It gave official status to those languages in the courts and in the legislature, but didn't define them as official languages. And what does it mean to be an official languages? Well, read on. They have equality of status and equal rights and privileges as to their use in all institutions of the Parliament and Government of Canada. So it's at the federal level only here. We're not talking about the provinces. We're only, and paragraph 2 is for New Brunswick. So leaving New Brunswick aside, no other province has constitutional language rights obligations. English and French are the official languages, and French and English are equal. They have equal rights and privilege as to their use in institutions of Parliament and government. Now, and we can talk about this in the question period if you'd like, but the reality is they're not equal. Canada is very much still an Anglo-dominant country, but at least now there are statutes and there are constitutional provisions that codify the goal, the aspiration of equality and substantive equality, not formal equality, but substantive equality between those two languages in all the institutions of Parliament and the Government of Canada. Section 3, paragraph 3 is also very important. It is the principle of advancement and progress. It basically states that nothing in this charter limits the authority of Parliament or a legislature to advance the equality of status of use of English and French. So by no means does the charter occupy the field with respect to language rights. There are federal and territorial and provincial legislations that advance the equality of status and use of English and French, and we'll talk about those in a second. But first, I'd like to talk about section 1 and provide you with this quote. It's a long quote, but it's one of the best, I think, judicial statements we have from the Supreme Court of Canada on what paragraph 1 of section 16 codifies. And it comes from Justice Wilson, who was dissenting in this case called Société des Acadiens versus Association of Parents, 1986, one of the trilogy cases of 1986 in language rights. And this particular case had to do with the right to be, not only to use the official languages of one choice in the courts of New Brunswick, but also the right to be understood by the judges of that court. In any event, here Justice Wilson says, I would read the opening statement, English and French are the official languages of Canada, as declaratory. So we're declaring the languages as being official, and the balance of the section as identifying the main consequences in the federal context of the official status which has been declared. Namely, that the two languages have equality of status and have the same rights and privileges as to their use in all institutions of Parliament and governments of Canada. And then subsection 3 makes clear that these consequences represent a goal rather than the present reality. We are still working towards this reality. They are something as to be advanced by Parliament and legislatures. And this would seem to be in the spirit of Jones, which is another case, namely that the legislature cannot derogate from already declared rights, but may add to them. I agree with those who see a principle of growth or development in section 16, a progression towards an ultimate goal. Accordingly, the question is, in my view, and will always be, where are we currently on the road to bilingualism? And is the impugned conduct in keeping with that stage of development? So basically, we are a work in progress constantly. So section 16.3 said that provinces and territories and the federal government can enact legislation. And in fact, they have enacted legislation to further advance our official languages. And here's a list, and I'm not going to go through all of them and what they do, but Ontario has some legislation, Northwest Territories, Yukon, Alberta, and Saskatchewan, PEI, New Brunswick, Nouvelle-Écosse, sorry, Nova Scotia, my French came through there. Nunavut has legislation also protecting here the Inuit language in addition to the official languages of Nunavut, which include French and English as well. And I will talk about the Indigenous Languages Act in my closing remarks. Briefly, on part 5 of the Constitution, not only do our language rights cover the bulk of the provisions of the Charter, they are entrenched for the most part using the most stringent level of constitutional entrenchment. They can only be amended and modified by unanimous consent. The use of English and French in this country, and therefore the status of French and English as official languages, can only be amended by unanimous consent of all the legislatures and the federal parliament. That is the highest level, reserved for certain questions of high national importance, including, I would say, the office of the Queen. But this is basically section 41 contains those elements that are deemed to go to the heart of the Canadian polity. And that would include our official languages. So that is, I think, another telling sign of the importance our official languages hold in our national identity. And then there's section 43B that allows provinces, certain provinces, or I call this the bilateral formula, where under part 5, provinces can, like New Brunswick, declare themselves to be officially bilingual, and they can do that by way of bilateral agreement between the legislature of that province and the federal parliament. So so this is a provision that was invoked by New Brunswick to become an officially bilingual province under the Constitution. And there's a group in Ontario here wanting Ontario to do the same and follow suit with New Brunswick. Finally, Part 7 of the Constitution. And this, I could talk an hour just on this one, on Section 55. But when we ask ourselves, what does it mean to have a bilingual constitution? What does it mean to have two official languages under our Constitution? Well, the framers of the Constitution figured out that, well, one of the things it must mean, surely, is that the Constitution itself should be bilingual. And yet, it is not. So the Constitution of Canada is defined in Section 52 of the Constitution Act of 1982. And it's actually not one document, not two documents, but a whopping 31 documents make up the written Constitution of Canada. And out of those, only nine have force of law and are binding in both official languages. The bulk of our constitutional documents were enacted in England by the Imperial Parliament or by the Imperial Cabinet in the case of regulations and other terms of adhesion for the provinces of British Columbia, for instance. In any event, the bulk of our written documents that make up our Constitution were enacted in England and therefore only have force of law in English. So Canada's Constitution is not binding in both official languages, including the Constitution Act of 1867, the British North America Act. It was drafted in both languages, and even though it codifies certain language rights at Section 133, the version that received royal assent in England was the English version only, and that was an historical accident. It could have been avoided, but it wasn't. So in 1982, at Patriation, the fathers of the architects of the new modern Constitution decided that we should fix that, because how can a country be constitutionally bilingual if the Constitution itself is not? So Section 55 was enacted, and it provides as such: a French version of the portions of the Constitution of Canada referred to in the schedule shall be prepared by the Minister of Justice as expeditiously as possible. And when any portion thereof sufficient to warrant action being taken has been so prepared, it shall be put forward for enactment by proclamation issued by the Governor General under the Great Seal of Canada, pursuant to the procedure then applicable to an amendment of the same provisions, blah, blah, blah. And once enacted, Section 56 provides that all those documents will be considered to be the Constitution of Canada, being equally authoritative in both English and French. Now, Section 16 makes Canada a bilingual country under the Constitution. The Constitution itself is not yet fully bilingual. Section 55 creates this binding obligation for the Minister of Justice to cause to be produced a French version of the Constitution. And the Minister of Justice in 1984 did do that. They created a constitutional drafting committee that got together and drafted a beautiful French version of all our constitutional documents. And they've been prepared and tabled in Parliament as of 1990 by then Minister of Justice, the Right Honorable Kim Campbell, who would become Prime Minister. But since 1990, they have not been enacted. So the second part of Section 55 remains unfulfilled. And yet it says they shall be put forward by enactment by proclamation. And yet we've stalled. Canada on this issue of the bilingual constitution has completely stalled. Why? Well, there are explanations for that, and I'm happy to take questions on that in the end, but it's a problem, and it's a problem that needs to be resolved. So my time is running out. The road ahead, what do we see? Well, Section 16 calls for Canada to become an official language, a country with two official languages. And we enacted, as I said, in 1969, the Official Languages Act. those provisions were entrenched in our Constitution in 1982. In 1988, we enacted the modern Official Languages Act, but it has not been modernized since. Next week, I'm very excited to say, this is like Christmas for me and for my colleagues who work in the area of official languages, right? There will be a new bill, a new Official Languages Act bill at the federal level, which will include, among other things, those provisions that will make the Supreme Court of Canada perhaps fully accessible in both languages without the aid of interpreters. So that is definitely something to look forward to. One thing that needs to be completed is patriation itself. I maintain that as long as we have not made good on the obligation at Section 55 of the Constitution Act of 1982, patriation is not complete. The act of patriation was about bringing home the Constitution, giving ourselves a truly Canadian Constitution, a bilingual Constitution, and that's not done yet. So as long as that's not complete, the work of patriation is not done. Senator Joyal and myself, he's the man pictured right here, he's now former Senator Joyal, we filed a lawsuit in the Quebec Superior Court in 2019, basically requesting the court to order Canada and the province of Quebec to start the dialogue and to make good on the promise, on the obligation contained at Section 55. And that litigation is ongoing. And finally, I think we need to talk about Indigenous languages and the act of recognizing other official languages than French and English in Canada. And I think we are well on the way. I'd like to highlight two recent developments: the Indigenous Languages Act of 2019, which does not create Indigenous language rights per se, but recognizes the possibility of Indigenous language rights being recognized under Section 35 of the Constitution Act of 1982, which is an important development. Parliament has taken the stance that Indigenous language rights do exist, that they flow from Section 35, and therefore have constitutional weight to them. And finally, thanks to Romeo Saganash, who is pictured here under his leadership, we have now the UNDRIP Act, which was finally enacted in 2021, which implements, or at least starts the process of Canada fully implementing UNDRIP, the United Nations Declaration on the Rights of Indigenous Peoples, which also contains language rights, and Indigenous language rights to education, to access to their own schools, legal system, school systems, the right to revitalize, to use, and to transmit to the next generation Indigenous languages, and also to the right to establish their own media in their own languages. So these rights are all contained in UNDRIP, and under the UNDRIP Act will need to be implemented as part of Canadian law. So the field of official languages, I think, is very interesting. I'm very passionate about it. There's a lot of interesting things ahead. And I think I will stop. It is now almost a 1:45, so I will stop my presentation. And I'd be happy to take questions on anything related to my presentation. And I will stop sharing my screen so you can see me in full. Voilà.
Voilà. Merci beaucoup, François. That was very, very interesting, sort of a very broad historical. It was good to get back to the basics. It just reminded me that French is my first language as well, even though I'm from Alberta, Franco-Albertan. But when I was in school as a person before Canada became a bilingual country, I don't think they were not allowed to teach French for more than an hour a day. So we had all of us to learn English. Les bonnes sœurs had to teach us English, all the students that went to school, because
before Section 23, there was no right to that French language education.
So it really changed the landscape. But anyway, so there we go. But so I just want to remind everyone that if you have a question, please put it into the Q&A. And if you see a question that you really like, there's a little thumbs up sign there, and please click the thumbs up sign, and it'll move the question up. But in the meantime, I see we don't have any questions quite yet. I'm curious, François, about this Section 55. And as you know, I've been interested in that section myself. But you've launched this case with Serge Joyal, And what is your thinking about, let's assume the case is heard, it goes to the Supreme Court mandates that the section be enacted, they be, followed up on, and the word is shall in section 55. It should have been done. What is your sense? My sense is that the problem is political, and and so what difference will going to the Supreme Court make? Do you think that will jiggle things up enough that maybe it'll come back before Parliament? Or how do you think this is going to work?
I'm looking forward to to seeing how it all unfolds, but certainly our view is that Senator Joyette and myself, our view is that it's a rule of law issue. It's a rule of law issue. We have a constitutional provision here that says the minister shall do this, and which also creates and triggers a constitutional obligation for all the parts of our federation, the federal government and the provinces, to get together and approve these French version of our constitutional text, which are just sitting there on the shelf. And if to at least submit to the proofreading exercise of going over these translations and agreeing, does this newly produced French version say what the English version says, and are we happy with it? And if so, let's just enact them. And if they're not happy with certain terminological choices, then they can make those changes. But I think the causes for why we've stalled on Section 55, it has to do very much with the events of the 1990s and with the failure of Beach Lake and then Charlottetown, and I'm going to take a moment, if you don't mind, to plug my book that Linda Cardinal and I did on this issue. It's called La Constitution bilingue du Canada, un projet inachevé. So it's the unfulfilled project of the bilingual constitution. And one of the chapters in there, I believe it's from Justice Gramont, now Justice Gramont, Professor Gramont said that there was a certain constitutional fatigue that fell upon Canada in the 1990s after Beach and Charlottetown. And there was basically a fear that if we even discussed the translation of our existing constitutional text, that this would be seen as an invitation to reopen the Constitution and ask for more things or negotiate for new things. And whereas this is not what Section 55 contemplates at all. Section 55 contemplates a textual validation exercise, and yet that's the explanation of why it did not move ahead. So we're hoping now that enough time has passed that we can all agree that that this is an imperative obligation. It's not been fulfilled, and we need to if for no other reason than the rule of law, which I think is reason enough, we should do what the Constitution commands.
And will it require a constitutional amendment if it does go through?
That's what Section 55 says, right? I mean, they will not become constitutional documents until they are enacted under the Great Seal, following the appropriate formula for the different documents. It's not a simple exercise. There are 30 documents, and different documents will require different amendment formulas. Maybe the terms of adhesion of BC and Newfoundland will require bilateral agreement from those provinces. But the BNA Act, the Constitutional Act of 1867, will almost assuredly require unanimity. So
unanimity, yeah,
it's not easy.
It's a stumbling block.
Yeah.
Okay, we have some questions, so I'd love to go on about this, but let's get to them. One is from Art Grant from British Columbia. He says, I think that British Columbia and maybe Newfoundland are the only provinces where English is the singular official language. For instance, Rule 22-3 sub 2 of the BC Civil Rules stipulates that unless the nature of the document renders it impracticable, every document prepared for use in the court must be in the English language, legibly printed, typewritten, written, or reproduced on 8.5 by 11-inch durable white paper or durable off-white recycled paper. So, what is your thought about that?
Well, I think he's correct that BC and Newfoundland are the provinces that do not really recognize or have made special provisions in their laws to accommodate the other official language. There are, of course, obligations that apply through the criminal code. Section 530 of the criminal code grants the right for everyone to have a criminal trial in French, if they so choose, even in British Columbia and even in Newfoundland. And of course, the biggest case on this point is called the Queen versus Beaulac in 1999, which was on which gave us the modern principles of language rights interpretation. But there is movement in Newfoundland, I'm happy to say, on at least creating a French language services policy for its French language population. But yes, BC is a special case in all of Canada.
Okay, bookended.
Yes, isn't it? That way.
Yeah. Are there efforts being made, to your knowledge, to move the English language provinces to allow for the use of French in the courts?
So, great question. Right now, French can be used in the courts of New Brunswick. Obviously, that's a bilingual province. French is the official language of the courts of Ontario under our Courts of Justice Act, Section 125. French is an official language of the courts of Manitoba. French may be used in the courts of Saskatchewan and Alberta, thanks to the Languages Act of 1988, which was a response to another case called Mercure, the Queen versus Mercure. So we can use French to different levels in most provinces, and even I would say in BC in criminal cases. So right across Canada in criminal matters, we can use French. And under new provisions under the Divorce Act, also we can get a divorce in the official language of our choice across Canada. So those are different new provisions, and which includes the right to a francophone judge, to submit francophone documents, and to obtain a bilingual decision from the courts in those cases of criminal and family law matters. So there are efforts being made, even in the English language provinces, to allow for the use of French in the courts.
Thank you. Now, how might bilingualism change if provinces were all to become bilingual?
Well, and I don't know if that's at all in the cards, frankly. The fact that we have a federal government that is committed to official bilingualism is not likely to change at all. I think at least I think the conditions of official bilingualism at the federal level is inextricably linked to the continued existence of Canada as it currently stands. If Quebec were to secede, then perhaps that would change the conversation, wouldn't it? I think that if all the provinces become, or at least if more provinces like Ontario become constitutionally bilingual, then that would, I don't know. I mean, the question is, how might bilingualism change? It might just become more normal and might seem more normal. And definitely out in my neck of the country, which is sometimes referred to as the bilingual belt, New Brunswick, Quebec, Ontario, it's sometimes referred to as the bilingual belt of the country. And I would include Nova Scotia and also Manitoba, which have constitutional, well, at least Manitoba has constitutional obligations on bilingualism. It would just normalize, I think, the use of French in our public institutions, both federal and provincial, and it would, I think, perhaps it'd be good for national unity. That's the whole idea here. The idea of these official languages was to create a polity, a Canadian polity, where the two colonial powers, at least, would be well represented.
See, we'll take one more question just before we sign off here, and that is, in the is the SCC's holding, the Supreme Court of Canada's holding in MacDonald, that per Section 133, parties have the right to use, as opposed to the right to be understood in, the official language of their choice before Quebec courts, still good law?
To my knowledge, both that particular holding in MacDonald, as is the one in Société des Acadiens, which is the companion case to MacDonald, they remain good law. They have not been, they have not changed. The Supreme Court has not weighed in again on those. I think there are certainly a lot of groups that would like the Supreme Court to readdress those issues under modern principles of interpretation of language rights. Now, for those who may not be familiar with that case law, that's a pretty inside baseball question. But in just broad strokes, in that trilogy of cases in 1986, MacDonald, Bilodeau, and Société d'Acadiens, the Supreme Court defined a very narrow view of language rights, saying that since language rights are negotiated and arise out of political compromise, that itself sort of should caution the courts to interpret them narrowly and not broadly and purposively, and to restrict rights rather than expand them. And therefore, when the section says you have the right to use the language of your choice in court, that's what it means and no more. So I can speak French to a judge, but I'm not entitled, I don't have the right for that judge to understand what I'm saying. He or she can understand me through an interpreter, and that would be the narrow reading of that right. Now, a lot of people are saying that, well, under the modern interpretation that came through Bolac, the case I mentioned earlier under Section 530 of the Criminal Code, a new paradigm was issued by the Supreme Court. And the paradigm is that no, language rights should be read broadly and purposively and generously with a view of supporting minority language rights communities throughout Canada. So Anglophones inside Quebec and Francophones outside Quebec. And that's what the whole scheme of language rights is meant to achieve anyways. I think that using the new paradigm, the Bolac paradigm, perhaps if the MacDonald and Bilodeau and certainly the Société des Acadiens question were to arise again, perhaps we would arrive to a different result.
Okay, well, we'll see what happens going forward, I guess. I'm sorry we can't get to the last question. We've come to the end of our time, so my apologies regarding the person who's asked the last question. But François, you know who this is, and tu peux peut-être le répondre on your own, perhaps just on a one-on-one there. So I just want to thank you very much for this very thorough review of this very unknown section, really, of the Charter. And many, many people do not understand Section 16. And so it was really wonderful to hear the history, how we've come to be where we are as a country, why we have two official languages, etc. It's important for us to remember these things, especially given where we are in our history at this point in time. So thank you very much, François, for your presentation. And I'd also like to thank Zara Ahmed, our center administrator, and Alina Rietsma, our public legal education coordinator, for their work in preparing and advertising and running this webinar. Thank you to our audience for your interest and participation. And I'm reminding you that the webinar has been recorded and will soon be available through our YouTube channel and on the center's website. And lastly, just a reminder that you will be receiving a little link to a short feedback form following the webinar. And if you would take just a few minutes to fill that out for us, we would greatly appreciate it. We value your feedback. So thank you all very much again, et merci beaucoup. Salut, bon weekend. Bon weekend.